Hi, I'm Nikki, and welcome to Relitigated, the podcast where five legally uninformed friends retry a real Supreme Court case. This episode focuses on Weeks versus the United States and is the first episode in a three-part series that traces the development of what is known as the Exclusionary Rule. Quick note before we begin. We try our best to get the facts and decisions in the case as correct as possible, but you shouldn't trust our legal knowledge. Enjoy the show.
Wait a second. I didn't know we were recording. I just came back. Wait a second. I came back with my water. I didn't know we were recording.
Oh, yeah, no, we were totally recording.
Start over.
Let's get started. I'm your host, Nikki, and I am joined by my co-host, Jarrett.
Hello.
We also have three friends who will be role-playing as our justices today. First, we have Adam playing an associate justice.
Wait, role-playing? I thought this was like a legit job.
Sure, with no money
All right.
attached.
Yeah, fine. I guess I'm your associate justice?
Hell yeah.
Hell yeah, I am.
Also playing an associate justice, we're joined by Chris.
Hello.
And finally, as our chief justice, we have Sarah.
Hola!
If you're new to the show, here's how it works. Jarrett and I have selected a real Supreme Court case, and our justices have no idea yet what that case is. We'll present the case and the story behind it and allow for a few questions. Then we'll move into oral arguments, where I will role-play arguing for one side, and Jarrett will role-play arguing for the other. Our arguments do not necessarily reflect our own opinions. It's just the gist of what was or may have been argued at the time, from what we can tell anyway. We each get 7 minutes to make our case, during which the justices can interrupt us and ask any questions they like. Once the arguments are done, the justices will deliberate with each other and decide on their individual opinions. The final ruling does not need to be unanimous, y'all. Majority rules. After that, we're going to reveal when the case took place and what the actual ruling on the case was. And then we'll close with a discussion of the case's impact and how we feel about it. And as always, a disclaimer, we're not lawyers, and none of what you're about to hear should be considered legal advice. Jared, are you a lawyer?
No.
How about our
Definitely not.
justices? Are you guys lawyers?
I'm pretty sure I'm like legally prohibited from ever becoming a lawyer.
Not allowed.
That feels
I'm
right.
about
Absolutely
as
not.
I feel
far
that.
from it as you could possibly be. Probably especially as far from an actual chief justice.
Is there a background check
may
involved?
possibly be.
Because I'm definitely failing that.
Yeah.
Not good.
You're all here for community service
Oh,
purposes.
yeah, exactly.
Oh, that's good.
Yeah, I'm here to stay out of court, man.
Yeah.
Mhm. I knew this felt like punishment. I just couldn't really put my finger on it. That makes sense.
All right. So, are we all ready to begin?
Lego.
Woo.
That's what they say in court, right?
Oh, shit.
Tally ho,
yes.
actually. Tally ho.
Oh, yeah. No, exactly.
Ah, yes, of course.
Yeah.
We wouldn't know. We're not lawyers.
Oh,
so.
yeah. No, not lawyers. All right, Jarrett. How about you introduce our case for this episode?
Absolutely. So this week, or this episode, our case is Weeks v. United States. That's weeks as in like weeks of the year. Real quick, just up front, we avoid using people's names, even though they are a matter of public record. The names don't actually matter, so there's no reason to dredge up specific people just to talk about the case. And in this particular case, I'm just going to use initials. So heads up on that. There we go. All right. Among the bustle and the hustle of Union Station in Kansas City, Missouri, police officers approached FW while he was at work, and they arrested him. He'd been suspected of sending lottery tickets through the mail, and while FW was being arrested, other police officers went to his house to find evidence to prove it. His neighbors told them where he kept his key, and the officers used the key to enter the house. They searched his room, took assorted papers and belongings, and then they turned those papers and belongings over to a U.S. Marshal. Later that day, officers returned with the same marshal out of the belief that they might find additional evidence on a second search. They knocked on the door. Someone in the house who was probably like a renter just let them in. The marshal searched FW's room and took more letters and envelopes and other things that he found in a chest of drawers that were amongst all of his other belongings. Important to note, for both of these searches, there was no search warrant. So these were 2 warrantless searches conducted on the premises. Ultimately, FW was indicted in the Western District of Missouri Federal Court on 9 charges, and the 7th count was a criminal offense for using the mail to transport lottery tickets. Before the trial, FW took legal action against the police, petitioning for the return of his possessions. His claim was that the police took, amongst other things, quote, all of his books, letters, money, it should be known, and we'll get to this later, like a lot of money, papers, notes, candies, clothes, end quote, expensive items, and a newspaper that was published in 1790, which was considered an heirloom. He also stated that the district attorney, the marshal, the clerk of the court did not return the items to him. And according to FW, the seizures violated the Constitution of Missouri and also his 4th and 5th Amendment rights under the U.S. Constitution. Now, in response, the court did order the return of any property that was not actually pertinent to the criminal charges against FW, but they did deny the return of materials that were related to the charges. So if the prosecution thought that the property related to the criminal charge, they didn't have to give any of that back, but everything else they did have to give back, which I believe, actually not sure if they did or not, but they were ordered to do so. The district attorney, it says, I should read my own notes. The district attorney returned some of the property, kept the rest, and stated that the property that he kept was evidence against FW. After the jury was sworn in for the trial, but before any evidence was given in the trial, FW again asked for his property to be returned to him, and again, he was denied. The papers that were seized from FW were used as evidence against him, and FW again objected on the grounds that the papers had been obtained by breaking into his home without a search warrant. He again argued that this was a violation of his 4th and 5th Amendment rights. His objection was overruled. The evidence entered included lottery tickets. There were statements referring to that lottery. There were letters written to FW about the lottery, and he was ultimately convicted of transporting lottery tickets through the mail. Although, if I remember correctly, from all of the charges that were brought, only the one criminal charge was the one that actually resulted in a conviction, and largely because of this evidence.
Yeah, that was my understanding as well.
Yeah. So FW challenged the failure of the court to order all of his property returned, as well as he objected to the use of his property against him in trial, and ultimately petitioned the Supreme Court to have his belongings returned to him and his conviction reversed. So the question that's now posed to our court is this: was the district court in error when it did not return all of FW's property and instead allowed it to be used as evidence against him, which thus resulted in a violation of his 4th and 5th Amendment rights?
Let me ask a clarifying question.
Yeah, how about it?
How is selling lottery tickets in the mail a lucrative business? What?
Thank you. I was wondering the same thing.
Like,
why do we care?
Can we just dig into this business model for a second? How does that work?
Not like lottery. Like,
I mean, the guy had a
he was
job.
running an illegal lottery.
He was running the lottery?
A lottery.
I mean,
Illegally.
sure.
Oh, and he held the jackpot. I get it.
Yeah.
It's
So
not like
the government
lottery.
generally reserves the right to run a lottery, and they don't like competition, turns out.
Yeah, understandable. I thought he was selling like state-issued lottery tickets, and that was somehow a business model. Okay, this makes way more sense that he was running his own lottery. Somehow that makes more sense. Okay.
That's not
a bit
very
of-
pro-free market of our government to have
Right?
that stance.
Let's just gloss
go
over
off.
that inherent contradiction. So the initial search, though, I'm gathering that was illegal. He was stopped at the train station? Why was he stopped at the train station? Can we go into that?
Oh, he was arrested.
He was arrested at the train station.
Yeah.
Sorry. Lead us through the sequence of events that led to him being apprehended at the train station.
Oh,
again.
he works there. So they
He was
just
at his job at
Yeah,
the
they
train
just-
station.
they just
I think he worked for like
snatched
an
him up while
express
he was-
company.
Sure,
Yeah.
sure, but like the original, why did they come to arrest him at his job? They searched his apartment, but what tipped them off to search his apartment in the first place?
He got tattled on, right? His neighbor.
Unclear as to what. The first search of his home and the arrest happened at the same time.
Yeah, so they went to him. They knew he was at work. They went to his job and snatched him up. And other officers at the same time went to his house.
Curious.
This guy totally got ratted out.
Feels like it. So he was on their radar for this. Something happened that they said, okay, go pick him up. And some folks were going to do that. They said, oh, and also let's go search his house. So they did that. The second search happened later that same day, but I guess after the arrest. They brought what they found to a U.S. Marshal, because I think it was local police who did the
Yeah.
arrest and did the first search, but they found evidence of like using the mail for conducting illegal activity, which is a federal crime. So I think they went to the Marshal, and the Marshal looked at it and said, oh, I should go do a search. And went back to the house and initiated a second search. And that search was, he literally went to the door, knocked on the door, and somebody inside the house opened the door. And he was like, I'm the Marshal. I'm here to do a search. And that person was like, okay.
Appeal to authority. Yeah, that's no good. Just let him
And-
in? That's crazy.
Yeah. And so that's the story of the second search. So yeah, timing's interesting on this, but all of both searches and the arrest, all on the same day.
But to be clear, the very first search, did they or did they not have a warrant?
They didn't.
Definitely
Nope.
did not have a warrant.
Okay, yeah, see. I don't know, man. The government, has to follow the rules or else what are we even doing here?
Yeah, and no jury or anything? Or was the jury at the trial?
Well, yeah, there
Jury
was
at the
a
trial.
Yeah, there was. Yeah, once he went to trial, there was a jury.
Okay, but
So I think that now would be a great time to remind us all as erudite, highly educated, extremely not lawyers, but justices, nevertheless. How are search warrants made? Tell me how search warrants are made, Chief Justices. No, seriously, how do search warrants get made?
Well,
don't cops do it?
Yeah,
District attorney?
the police officers go to a judge.
And they're like, could we search this place up? And then the judge says yes or no. And if the judge says yes, they get a paper with the judge's signature on it.
Okay, so law enforcement gets evidence. They collate the evidence. They bring it in front of a judge. They say, hey, judge, we would like to just temporarily violate this person's rights just for a minute, just to make sure they're not holding a gun or whatever. And the judge is like, yeah, totally cool. This guy probably has a gun. Might be smoking, metaphorically speaking. And then they can go and ransack your house and just search whatever.
Not whatever. First, they have to have probable cause. So that's what the judge asks them for.
Okay.
What's your cause? What's a probable cause?
Well, maybe we
to do
should
this search.
just, I guess, make our arguments then, because it sounds like the justices just have so many questions.
So many.
I was
always.
going to ask if we were in arguments yet. I was a
No.
little confused.
Not
Okay.
yet. We're still
Very
in,
good.
We're about to
still
argue with
just
someone.
Yeah, we're in facts of the case mode.
Okay.
Yeah.
Discovery, if you will.
That's exactly
Or
right.
maybe not.
Is that
Oh
what
my
they
God,
call
I
it?
was right.
Wow.
Oh,
Guys,
nailed it.
I'm
Are you
at this
sure?
point, I'm basically a lawyer.
You're sure
Fact
you're
discovery.
not a lawyer?
Man, I can't wait for some actual lawyer to start a podcast that just takes us down. I'm gonna enjoy that
deserve
so
it.
much.
Just
Yeah.
it's
Yeah.
just like this is why these 5 idiots need to be stopped immediately.
Please
Yeah.
destroy
Oh, we're
us.
going to get
Can't-
canceled.
Yeah, this can't
Oh,
continue.
I can't wait.
we can't get canceled if we have no idea what we're doing.
Somebody must stop us.
We can't get canceled if no one knows who we are.
Nailed it. Yep.
Guys, we're really cool and funny. Please don't cancel us.
Any more factual questions.
So no warrants.
Okay,
cops
so
get
no
warrants.
warrant. They ransack his house. They do it a second time under the auspices of some random dude letting him in. Yeah, that doesn't feel right. Doesn't feel right.
Yeah, so far I'm getting rancid vibes from the U.S. Marshal and all the people he's affiliated with in here. So really curious to see if you can argue your way out of this one. We'll just see.
Wow, that's a hostile opening take from our Chief Justice.
What was that? What was that confirmation hearing like? Like, how would you rule in this case? This is my exact answer down to the letter.
I will
Absolutely no
shank you.
ambiguity. This is my position.
Oh gosh. No, you can just kind of tell already, like, just from the pointed questions from the justices that, like, yeah.
So you're saying I've got an uphill battle. Okay. All right, I
Good
get
luck,
it.
buddy.
All right, I'll be the heel. That's fine. But you know, I'm not the petitioner in this case though. So what I will do is I will put 7 minutes on the clock, and Nikki, playing the petitioner, will go ahead and give you the argument that you all seem to already agree with anyway.
Yes.
Nice.
Confirm our beliefs, Nikki.
So yeah,
Go ahead.
wait, has the clock started yet?
Yep.
Oh God, I can't manage my time. Okay. All right. So yes, I come to you, justices, on behalf of FW, and I just want to remind everybody, because we all know this as, legally educated people, right? That the Fourth Amendment protects, quote, the right of the people to be secure in their houses, their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Fifth Amendment says that no person shall be deprived of life, liberty, or property without due process of law. So the original framers clearly intended these amendments to protect citizens and their property from unreasonable intrusions by the government without authorization. So this means that not even the government can just enter a man's home and take his stuff, especially without some sort of authorization or official process. And the court has already held in Ex parte Jackson that this protection extends to letters and sealed packages in the mail. And where there are exceptions and when searches and seizures do happen, there have to be certain safeguards. So there needs to be warrants with oaths and truthfulness and specific descriptions of what the police are looking for. And that means everything else is to be left alone. So this is core constitutional liberty. Okay, we are talking about government invasion into a person's home and into his personal business. And it's one thing to open his doors and to go through his drawers, and that's the nature of the complaint here, but really what this is about is the utter violation of his right to privacy and liberty, especially when this man has no prior conviction. And really, a case like this cuts to the essence of what the framers of the Constitution had in mind when they wrote it. So, once again, the intended purpose of the Fourth and Fifth Amendments is to limit the wide power and authority and resources of the US government and federal officials against citizens, who have basic rights. So these amendments prevent the government from making up an excuse to just violate somebody's rights, regardless of whether they're accused of a crime or not. And these rules apply to anyone acting under color of the government. So it's not justified, to engage in this behavior just to get a conviction, regardless of means. And I say that the courts are supposed to support and uphold the Constitution and provide a way for people to get protection and redress. I want to remind you all that there was no warrant. FW immediately asked the court for return of his belongings twice. So if the government can just enter a house, take private documents, and then use them against a person accused of a crime, there might as well be no Fourth or Fifth Amendment. So the marshal should have obtained a warrant based upon information that was sworn to be true and describing specifically what he was looking for. So I say that if the court allows this evidence in and allows it to be used in this criminal case, then basically this violates the intention and the letter of the Constitution. I want to point out that the court recognized that the behavior of the officials was inappropriate because it ordered the marshal or the DA's office to return some of FW's property. Its refusal to turn over all of his property and, just allowing the government to enter this property into evidence against him were errors in his case. And so for that reason, they shouldn't be used in court, and his convictions that were based on that evidence should be overturned. And with that, thank you very much for your time, and I will take any questions that you guys have.
No questions, but Jarrett, good luck, because honestly, there wasn't a search warrant. I don't really know why this is even a case.
I can see. I won't get into arguments, but I can see both sides. But yeah, no warrant is not a good look.
Big red flag on Uncle Sam's part, I would like to say.
Yeah, yeah, I want to be fair about this and was the dude a criminal? Obviously, yeah. Clearly is running a weird personal homebrew lottery. I think that's legal. That's probably illegal.
My client has no criminal conviction. So, based on what are these, what they're using against him is stuff that they just went into his house and went through his stuff and just grabbed it up and used it against him.
Do I respect his hustle?
He seems
immensely?
Sketchy.
But
sketchy, but
that said, my question is, how was there no warrant? If they were able to produce evidence, if the state thought that they could secure a conviction based on that evidence, why weren't they able to get the warrant in the first place? Why was that not possible? Why did they try and fail? What's the story there?
I don't know that there even was trying. I think they just arrested him and went to his house.
Interesting.
The same day.
I really want to know, what was the informant? Who tipped him off?
Somebody snitched big time.
It must have been, right? And that, that's what makes this so troubling, right? Clearly whatever evidence they had that made it feel warranted to go and raid this guy's house was not secure enough to go in front of a judge and get a real warrant. But interesting.
And turns out that is my time.
Thank you, Nikki, for your wonderful points.
Thank you.
Thank you.
Okay.
Yeah, you're gonna need that deep breath.
Y'all ready for this?
You all ready to be converted?
Yeah, wow me.
Sell me. This is Shark Tank now.
Yeah.
7 minutes on the clock.
And for that reason.
Let me know when I'm good.
Oh, you're great. Actually, I don't know. I don't have the timer.
Just wait for the timer.
Okay, now.
All right. Miss Chief Justice, and may it please the court, the petitioner in this case, Mr. FW, is a criminal. They ran an illegal lottery. They used our federal mail system to aid them in perpetrating that crime, which just further compounded their lawbreaking. Yes, the Fourth Amendment states that, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. That's in the text, absolutely. But I posit that there was no violation because the searches of FW's premises and the seizure of material that proved beyond a reasonable doubt that he was in fact guilty was not unreasonable. It was, in fact, perfectly reasonable for officers to search the premises of an individual that they were already in the process of arresting in order to gather further evidence. That the information they found further showed that their beliefs were accurate makes the search seem even more reasonable. The federal marshal, who was presented with papers indicating that a crime was being committed, was eminently reasonable when he decided to take a look for himself, a conclusion that yielded even more incriminating evidence. And yes, of course, having come across that material that showed that a crime was being committed, it was their duty to seize it as evidence. I want to note that these searches were not break-ins, not by any stretch. No one kicked in any doors in the middle of the night. A kindly neighbor identified a key for the officers to use. When the marshal came, literally a knockin', someone in the house let him in to conduct his business. At no point did the officers encounter any resistance to their search activities. They were literally let into the house. So, to further illuminate the reasonableness of it all, when FW asked for the return of his property, the district court did the sensible thing. They ordered the return of property that had absolutely nothing to do with his conducting an illegal lottery, which, by the way, he absolutely was doing and was convicted of. After all, why should someone be given back something used in furtherance of a crime? Consider this. If the property seized was a weapon, not just papers, would you feel comfortable returning a firearm to the murderer, proven to be a murderer by that firearm? You absolutely would not. It would be unreasonable to do that. That the evidence acquired just happens to be so damning for FW is insufficient reason to return it to him now that it has been seen by officers of the law. It is now known, it is known to be illegal, and so it is seized. And on the topic of papers being used against FW, there is precedent allowing for this. In a case 10 years before this one, known as Adams v. New York, the Supreme Court held that when evidence is brought before the court, it does not matter how the evidence was obtained. To quote that decision, the fact that papers, to quote that decision, quote, the fact that papers which are pertinent to the issue may have been illegally taken from the possession of the party against whom they are offered is not a valid objection to their admissibility. The court considers the competency of the evidence and not the method by which it was obtained. End quote. Sure sounds to me like the Supreme Court was pretty okay with saying, I don't care how you got the evidence, but now that it's in front of me, this guy is guilty. While it is the opinion of this respondent that the seizure of FW's property, once discovered, was lawful, and the use of the property to convict FW was also lawful, I recognize that the court may look unfavorably on the searches being conducted without a warrant. And I grant that there is an overstepping there that may deserve redress. Insofar as that is true, then the court should punish the officers involved in the searches for their failure. This is a case of individuals being, let's say, less than perfect at their jobs. Their superiors should hold them accountable and perhaps even relieve them of their duties if they feel that this serves the will of the voting public in that jurisdiction. That one party should be punished for doing a bad job should not exonerate FW, who, regardless of how we came to know it, we know now for a fact is a criminal who did criminal things. If the justices today reverse the district court, they are letting a criminal go free and the officers responsible would also face no sanction. Does that sound reasonable? No, it does not. Justices, I rest and yield to questions. Thank you.
I hate it here.
Rough. Rough.
Yeah, and passionately argued, but I'm still going to go ahead and call this the Batman doctrine, which is to say that if you can prove that there was a crime committed, it really doesn't matter what means or methods you use to obtain the evidence of said crime, including throwing punks off of a 3-story ledge, etc. Sorry, that wasn't a question. That was really more of an editorialization. Yeah. I just really want to talk about Batman. That was really where I was going with that. So wait a second. Indubitably, this man was a criminal, like probably-ish. Still unclear on that.
But, for sure. No, he was convicted.
He was convicted. Man's a criminal.
Are you trying to say that we could and should theoretically monitor every conversation in this country for the presence of crime and then prosecute it warrantlessly should it be detected?
I'm saying that if the police make a mistake, if they are being a bad employee at that moment and maybe not fully following procedure, but in not following procedure happen to stumble across something that shows someone's doing something wrong, the state shouldn't shut its eyes to it just because.
Isn't that just a wanted invitation to bad behavior, though? Like, that's just inviting everyone to breach the. That's why I call it the Batman doctrine. It's encouraging everyone to be like, I'm just going to push this suspect a little bit further. I'm going to get the confession. That doesn't feel right.
I'm not asking the justices. I'm asking the justices to stay very, very narrow on this to the search and seizure. I'm not talking about
one
torture.
Time. I'm not talking about torture either.
Just one time.
You said torture. Those are your words. I just implied, roughing them up and just like being a little bit rowdy, Batman interrogation.
Torture is the next case that we hear.
Torture,
of course.
Egregious.
Yes, 3 p.m.
I believe my time is up. I thank you so much, justices. I know that you will do the right thing in this case and put aside your gut feelings for what is logically the correct answer.
I gotta be honest, I'm so unclear on what the right thing is, like most of the time.
Mm-hmm.
Yeah, just generally speaking.
Should we? Is there like one more follow-up question for each of us? Any of us?
Last chance, because once we move on to deliberations, Nikki and I become clerks and not respondents and petitioners.
I have a question. How many eventual counts were brought against this man? And how many of them actually, stuck?
I think there were 7 counts, but he was convicted on the... no, actually there were 9.
9 counts. The 7th one was the only one he was convicted on. That's where you got the 7 from.
Okay.
I see.
No further questions.
Thank you, Chief Justice.
On to deliberation. I'm sure this one will take a long time based off of the loud sigh from the dais.
You might say I've been deliberating this for about 15 seconds.
I hate this case.
Nikki and I are now your clerks.
Yeah.
You're demoted to clerks or whatever.
Who snitched?
Yeah, right.
Who snitched on this guy?
Yeah, right. That's the real underlying true crime puzzle to the story that I find interesting at a human level.
You know what? It's the neighbor's cat that told the
neighbor is extremely suspicious in general for knowing where his fucking house key is.
Yes.
No, that is why do you know that?
Yeah,
I don't know.
Even if they were let in, they're still technically trespassing.
Well, a renter let the police into
their house.
Yeah, the police showed up and
I'm
a renter.
This doctrine of oopsie daisy. Yeah.
No, I'm serious. I rent a house. Okay, if the U.S. Marshals come knocking on my door and say, "Hey, can we take a look around?" I'm gonna say, "You need to take it up with my landlord, dude. I don't, I feel like I don't have the authority for that." I don't know. I don't know anything about leases. I'm
Yeah.
not a lawyer, but
We
like,
also don't know what time period this was, right? Like, this may have been a more credulous time where
oh my
you're just
god,
like,
right? Wait,
oh,
when
man,
was
like,
this?
12 cops on my step? Like, 12 cops can't be wrong. Against little old me? Like, who am I to question them?
And 12 cots and 0 warrants. Like, I
I'm
don't know.
assuming, yeah, right?
Yeah. What, like,
Seems-
not a single cop could get a single silly little warrant?
Literally every
I just feel
judge
like
was on
on
the country club that
principle,
day.
yeah, I just feel like on principle we should just like not even like consider Jared's argument because of the like how silly it is for them to not even have a warrant. Like in this day and age.
Mm.
Ouch.
I don't care that he was a criminal. I mean, like, I do. Like, you shouldn't really be like try not to
Honestly,
be a criminal.
I respect
guys,
his hustle. Running your own lottery is no easy feat. That's like, that should be
I'm
legal.
sure-
Right?
That's a lot of work.
I'm sure he built that brick by brick, you know?
Right? And this was a time period where you're running this business by mail? Like,
Yeah.
that's crazy.
Yeah. What?
Not even the
Pony
internet.
Express? Like,
Right?
Old bars. Jeez.
Doesn't even have the fucking darknet. He doesn't have blockchain. This man is a pioneer. We should put this man
This is the
on,
original
on
Bitcoin.
our
actually.
currency.
yeah, we should get FW on this podcast to hear,
Sorry, I've been
his thoughts.
really enamored with this guy's go-get-him attitude, industrial spirit. What are we talking about? Okay, wait a second. So this guy's definitely guilty.
A criminal.
He's a criminal. Ran an illegal
Convicted
lottery.
criminal.
Indisputable. Marshals figured him out. But I just can't get over the fact that they use the key under the doormat. That's just...
Yeah. It still feels like trespassing.
Exactly.
So, like, what if they just happen to stumble upon something that's incriminating? for
That's
him,
interesting.
right?
What if he had like a
Those-
picture window in his living room? That they
Right?
could
And
see
they were
his
just
giant
like,
stacks
ooh.
of homemade lottery tickets through? I'm unclear what the evidence would be.
like dumb. Yeah, not a smart move. But that would do it. But the fact that they trespassed into his property and discovered these things, that's a violation.
But then again, it was such a soft trespass, right? Like,
Yeah.
if they had broken through the window, I feel like this would be real cut and dry.
It's very demure trespass.
Demure, very
Oh
cute.
boy. Oh boy. Oh boy.
I'm also curious, why was this even considered like a reasonable search? Like, what evidence did this snitch have? You know what I mean? Like, it just all seems very subjective. Like, oh, well, it was reasonable for the marshals to go in. Like, what? How? I mean,
We
I
get
don't
back
know.
to the original snitch question. Who
No.
teed off the marshals?
Also, the fact that the arrest happened the same day of the seizure.
And, guys, I've seen Serpico. I know enough to know that, like, if they obtain this evidence and didn't want to go get a warrant based on it, it probably wasn't good the way they got that evidence. Just saying.
Oh, for sure. Yeah, I don't know. I feel like the Fourth Amendment is
Among the best amendments, the greatest
Yeah.
amendments.
it's a pretty good one.
It's a
I'll say
quality
that.
amendment.
Uh,
It's a nice square number.
it is,
It's a foundational,
Yeah.
if you will.
I was
Divisible
going to
by
say
2.
it's divisible. Oh yeah, there you go.
Yeah.
See, I'm not a lawyer or a mathematician, so I
Right.
don't even. Maybe we
Anyway,
should.
it's very important.
Maybe numbers scare me, Adam. Maybe let's not talk about those. See, you mentioned divisible by 2, and I lost my train of thought. All I know is that I think Nikki's argument was better.
Yeah, indubitably.
And I don't really love cops. Sorry if you're a cop and you're listening. I'm sure you're a wonderful person, but as an institution, I'm a little afraid of you.
Anyway, all I'm saying is that, like, I respect this guy's hustle. I think that's my point. I respect this guy's hustle. Running an interstate lottery, homebrew, from your apartment, through the mail, and, like, obviously the marshals are going to figure that out eventually. Like, you're using the federal mail. But still, like, they should have gone through the proper channels, gotten the evidence
That's a
without
good point.
beating a man half to death, brought it before a judge, gotten the warrant. Like, this guy's not threatening life and limb. He's not a terrorist. He's just... I'm not really clear what social crime he's committing. It's illegal, probably, I assume. But, like, what harm is he really doing? Given that, like, it's not life or death. He's not going to blow up the Civic Center, right? He's not going to go I don't know, drive
not
a bus off a
endangering the
cliff. He's not
public.
endangering the
That's right.
public imminently. So, like, go
Right.
through the due process to get the warrant. Like, why not? Unless you used really underhanded methods to get the evidence to get the warrant, is what I'm saying.
It just feels like the cops were trying to meet a quota, you know?
Is this a quota thing?
Yeah.
We have to bust 4 dudes running illegal lotteries per month if we're not doing our jobs.
We haven't really
And how
arrested
many
anybody
illegal lotteries
recently.
were there?
Apparently, too many. You could just like break into any dude's apartment and just bust a lottery. Like,
Jeez.
just all chock-a-block all over the place.
Yeah. Okay. Well, I feel pretty firm in my stance, Adam. It seems like you're pretty firm on the fact that FW seemed like he had a good business thing going, whether or not it was illegal. It was.
I feel really bad for Jarrett and just this general prosecution argument.
Jared will be fine.
He'll be fine, but I want to give him one more chance to convince us because
Do
That's
you?
not-
that was
not
a
how this works.
is it? I mean,
That's not how this works.
Order.
I mean,
order in my court.
do the justices not like basically make it up as they go? I'm not clear, actually.
I
Uh,
mean, who's going to tell you that you can't? Who has
Exactly.
oversight over you guys?
Our entire system works on good intentions and a sense that everyone's going to follow decorum. And the moment they don't, we have no idea what to do. So I'm going to break decorum. Listen, Jarrett, give me one more chance.
Are you basically giving me the opportunity to submit an amicus brief on my own behalf?
Yeah, if you want to get
Mhm.
fancy about it.
Okay.
That was a very lawyer term to use. Are you sure you're not a lawyer?
No, I mean, you just heard me argue. So
That's true. It was.
yeah.
Yeah. I
Can you
didn't.
give
You didn't
us-
move me.
Any insight into how the evidence was obtained that led the marshals to their initial search? Because that's what I'm really hung up on. Like the nature of why they decided in the first place that this guy was worth tailing, collaring, and like searching his house. I think those are official terms. Those feel really official. Like what led the marshals to those decisions in the first place? Do we have any insight into that?
Well, so there's 2 different agencies. So the original police officers, I think, were local police. We do not know what information they had prior to making the arrest. The marshal, the police walked in the marshal's door with incriminating evidence.
I see.
Got it.
So the marshal was just sitting at his desk, and all of a sudden a local cop comes in and says, "Hey, look what we found."
Okay, so this feels like collusion between the local police and the marshals to fabricate evidence. And I'm still led to this question of like, why did they not pursue a legitimate search warrant? Like, this is not a time-sensitive matter. Like, sure, the guy's going to mail out some lottery tickets or whatever, but
Well, I
like,
was going to say maybe it was.
maybe it
Maybe
was.
he was ready. He was about to like, maybe someone was going to win. You don't know. And
Just
then, you know.
It was a
So I
Powerball
mentioned this-
situation. Yeah.
Yeah.
Incoming
Let's give away
amicus
all this
brief.
money.
I mentioned this in my argument, and maybe I shouldn't bring it up again because if you're not talking about it, then clearly I didn't do a very good job. But the case Adams v. New York, in that case, the officers had a search warrant, but it was like a narrow. Every search warrant says these are the things you're allowed to actually look for. And while they were looking for those things, they found a bunch of other stuff, and they were like, "Well, we're here," so they took that.
Interesting.
That defendant sued and was like, "Hey, that stuff was illegally seized." It went to the New York Supreme Court, or I'm actually not sure what it's called in New York State, if it's a Supreme Court or Superior Court or whatever it is. And they were like, that doesn't violate New York state law. So then they took it to the Supreme Court saying it violated their constitutional rights. And the Supreme Court at that time, this is 10 years before this case, said, okay, so the police, were in error in how they seized it. But the court is not responsible for, waxing philosophic about the providence of how the evidence came before them, just whether the evidence supports the claim or doesn't. So I guess it could be argued that there was precedent in the land that maybe led to police not necessarily always feeling that they needed to.
Yeah. I can accept
But-
we don't accept we don't care
Sorry.
about the providence, but go ahead.
Yeah, I think, but I just wonder if that's like is that even relevant? Like, why they did it, does it matter, like, for whether or not the Fourth Amendment was violated? Like, whether the police erred because it was an oopsie or whether because they were malicious, does it matter?
Yeah, I feel like it matters.
It probably matters.
Yeah, I feel like you can't just.
It matters because one of the things you said that really stood out to me was the nature of how the evidence is obtained, and I'm paraphrasing here, isn't as relevant as what the evidence tells us about the nature of a crime that was committed. And that's really scary because that's just inviting wholesale fabrication of evidence to come to any conclusion that you want the court to come to. Right? If you don't care about the provenance of the evidence whatsoever, then like you're just inviting fabrication in my mind.
Yeah. Okay, anything else, Jared?
I think my amicus brief has gone far beyond what should be allowed.
Okay.
I am very surprised that there has not been objections from opposing counsel.
This is a very liberal, freewheeling kind of court.
I am in judges' chambers arguing my case, and opposing counsel is outside being like, "This is fine."
Are you familiar with give the man enough rope to hang himself?
Yeah, basically.
Yeah.
And my whole deal is they just went in his house with like no permission and just took up his stuff. And then we're like, also crimes.
Maybe this will help. The question is, was it wrong? Was the district court in error when it said, we're only going to give you some of your stuff back, and the other stuff we're going to hold on to because it pertains to your criminal charges? Was that wrong? Or should the court have said, yeah, all of this was taken from you in violation of your rights, and we're going to give it all back to you? And once they give it back to you, obviously it can't then be taken to be used against you in court. So
my position is
that's-
that it violated his rights under like literally the Bill of Rights.
And my position, my role played position is that the search was not unreasonable, and while yes, the officers may have been in error, that error should not change the fact that like this evidence is real and it proves he's a criminal.
Yeah. No. His rights were violated. I'm sorry. It's not gonna. And the whole argument too about like, well, maybe we should punish the police officers who, potentially illegally obtained this evidence without a warrant. I don't even. I'm like, yeah, you should do that too. I mean, I don't know. It all feels like if police are allowed to go into anybody's home because some rando snitches about something that's, mind you, this is not even like suspicion of like a violent crime. This is like,
hasn't even been corroborated by outside evidence.
It's not like bro was building a bomb in his attic.
Could be anyone's word that they went on.
Yeah, that's why I'm like, who is this snitch, right? Like, how reasonable is what evidence did this snitch have that made it seem so reasonable for them to just knock, 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 and walk in and search everything and take evidence without a warrant?
I just want to chime in that's literally what the warrant process is about, for the cops to go to a judge and be like, this is what we think this guy's up to. And the judge is like, why do you think that? And then they go through a back and forth, and the judge decides whether they can go in that person's house and take their stuff.
And I think that process is lovely, and it should be there. And it's there for a reason, to protect the rights of the citizens in this country from just being barged in on by the police for letters, like paper,
mere paper.
Like, let's be serious here.
This man was printing beautiful pictures with presidents' faces on them and distributing them to the public, and you wish to convict him for this crime? So, okay, this is where we're supposed to like go through the arguments of like, all right, what if this guy stole a bunch of polonium from like a medical lab, and the cops screwed up when they were searching him, so now we just got to give him his polonium back. Like, just taking this to its logical extreme. This guy stole a bunch of anthrax from the CDC, and the cops are really messed up when they read his Miranda rights. And now we got to give him his polio back. Like, I think that's what we're supposed to consider here. Like this notion that, the cops have clearly come into things that are either intended to be used to aid a crime, or in the process of aiding a crime, or have been used to aid a crime.
Yeah.
They have evidence to that extent, and now they're supposed to give it back just because they didn't follow some, procedural. Like,
I think I'm thinking about it like I like the gun analogy earlier. It's like more of a, well, was this being used like, so I'm, Fifth Amendment, right? The presentment or indictment, right? So like you're being presented with this evidence. Okay, the evidence was found, regardless of how it was found. It's now, it was used per the trial, right? He was convicted. So the evidence is now, okay, this belongs to that conviction. And so while it's true that he should have been, returned all of his property, now some of his property was actually elevated now to a new status of being used to commit a crime or as per the conviction. So I think it kind of changes status a little bit. It's more than just his property. But yeah, that's like really, it's really stretching it. That's really stretching it. So yeah, I don't know. Should have gotten a warrant.
Should have just
gotten a warrant.
You should have just
Twice.
gotten a warrant. Like
literally twice.
Twice. Thank you. Yes.
This whole
right?
kabuki is set up for a reason. If the good guys don't follow the rules, then what are we even doing here?
What are we doing? Thank you. Okay, justices, I think that we have had ample discussion. I think we, clerks, or I don't know how I should be addressing you guys, Nikki and Jarrett. Clerks, I think we are.
That's so demeaning.
Probably ready.
Minions, please come.
Yes, our minions. I think we are ready to give you our final decisions.
Yeah, lay it on us.
Yeah.
Okay. Well, associates, would you like to go first, and then I'll close it out?
You should not only let this man go, but you should put him in charge of like whatever local state lottery authority he wants to run. This guy's a go-getter. This guy has plans. This guy has dreams and ambition. Let this man run the state lottery commission. He's not a criminal. He's a go-getter. He's a white-collar, ambitious man. Put him in charge. I rest my case. Do I rest my case?
Rested.
Your case has been rested. Chris?
I concur. They should have gotten a warrant. This is a clear violation of rights.
Thank you.
Oh, yeah. Wait a second. That's what I was supposed to say. Yeah, they should have gotten a warrant. And the fact that they didn't means that this entire thing's a sham. It was all based on evidence that was like obtained illegally, right? Like, they don't get a warrant. The evidence is legally obtained. Like, and therefore, you should have all of his stuff returned. And there really is no evidence to like convict him upon.
Yeah. There you go, Adam. I knew you'd get there. Yeah, all I can say is ditto. Should have gotten a warrant twice.
All right. We have a unanimous decision from our justices on the side. They come down on the side of the petitioner that the searches were unconstitutional, and FW should be given his stuff back. And because they used that stuff to convict him, the conviction would get overturned.
All right.
There you go. I like. Sorry, just real quick, Nikki, Sarah, something you said earlier. It was just like, okay, yeah, the police screwed up. Fine. If you're saying that, like, well, we should punish them. Like, well, why don't we let FW go and punish them? So I think this should be known as our court is now setting the "por qué no los dos" doctrine.
Hell yeah!
Scholars have alternatively referred to it as the Uno reverse.
Yeah. It's not checkers; it's chess. You know.
The long game.
Yeah.
Awesome.
We should take the investigators and make them in charge of the illegal lottery and see how they like it. It's very
Ooh.
stressful. There's a
Not
lot of
a
ins and
Yeah.
outs. You got to pay
Not a
your
bad
employees on
idea.
time. It's all under the table. Very complicated.
It's cash business.
Or gold.
Oh yeah.
But seriously, like, I really want to know more about this guy's lottery empire.
I know,
This is
seriously.
fascinating.
How do you get in? Can I get in?
I'll
How
give
does
you-
one start a black market empire?
Just a little piece of trivia is that lotteries in American history have not been uncommon. You see this come up actually quite a bit in American history. This one is called policy, and Nikki and I have been obviously reading a lot of court cases, and we keep seeing like phrases like policy paraphernalia, and we're like, what the hell does that mean? And then reading, some write up or I think like a law journal or something like
We
that.
have to like Google stuff because we're not lawyers.
This is going to be a Wikipedia hole I go down. I can already
Yeah.
see it. I'm Googling this.
Ooh, boy.
Wait, no, don't
Yeah.
Google it yet. Because spoilers.
Yeah. Well, let's
Fair.
get into what actually happened.
Yeah.
Tell us
boy.
more.
All right.
boy.
Yeah.
All right. So we have the ruling, and what happened was the actual Supreme Court came to a unanimous decision, and this occurred in 1914.
Whoa.
That's a long time ago.
This is like at least 50 years before I guessed.
Yeah. Okay.
And so their ruling was that the Fourth Amendment limits the federal courts and its officers in their use of power and authority. And this is to protect individuals, their persons, houses, papers, and effects against all unreasonable searches and seizures under the guise of law. So the court held that the Fourth Amendment protects everyone, regardless of whether they are accused of a crime. And the Constitution is supposed to protect the great fundamental rights. And so all of those who are supposed to enforce federal laws are obligated to follow it. The courts are also supposed to protect constitutional rights. Therefore, they can't condone the execution of federal criminal laws for the purpose of getting convictions. They can't allow the government to keep the belongings of the accused for the purpose of evidence in proceedings unless there is a warrant. So if wrongfully seized, they must be returned. And if the defendant asks for return of the material in a timely manner and is refused, and the materials are used in evidence over his objection, then the conviction should be reversed. So this decision established the exclusionary rule. So basically that means the court cannot use evidence that officers obtain by illegal search and seizure. So
Wow,
basically,
Batman doctrine is soundly
You should
defeated.
see me fist pumping right now.
Yes.
So,
Batman is a fascist.
They
and we
knew
should
what's up
not-
in 1914.
Yes.
and yeah, they were like, so this removes incentive for federal officers to engage in illegal searches.
Right. It's a precedent. Yeah.
Some of my takeaways on this one is, I think of everything in sort of like, so what, right? Like, why did we bring you this case? Why is this case interesting? Especially because it seems for the three of you that you kind of already had we're going to go one way.
This
from the
feels like
beginning.
the case for establishing this kind of precedent, right? I think that's the sense I'm getting.
Yes, and so the exclusionary rule, obviously very important. It's probably what you were thinking of, even if you didn't know what the name of it was when we were going through the case. Certainly when I first started reading about it,
Batman doctrine.
I was like, this is weird. Isn't this a thing? And the answer is yes, it is. It's the exclusionary rule. There are some caveats that I think are important. Number one, this was a federal case. So the FW was tried in federal court by the federal government. So this ruling applies to officers of the federal government and the federal courts. What this case does not talk about
is the local police.
State courts.
Also want to point out it really didn't talk much about the Fifth Amendment, like at all.
Well, yeah.
Yeah.
That's true too. Yeah, it's just sort of like maybe they.
I tried to
they
bring
got-
it in.
Yeah,
Yeah,
they-
you did try, Chris. Good
I
job.
tried.
Yeah.
very much appreciated. Yeah, totally skipped it. I guess you really didn't have I guess if you're going in order, by the time you're done with the Fourth Amendment, you kind of already have the
We're
answer.
done. Yeah, it's
Yeah, we're
settled.
done there. I mean,
Don't even know what the
why
fifth
even
says.
go?
Don't care.
Yeah.
Yeah.
How dare
Another
you,
thing-
border soldiers in my home?
So
Wait,
another thing that I had in mind as I was, or like something that I walked away from in my research was the moment it hit me that I thought to myself, well, I think, Adam, you had said, wow, this happened 50 years earlier than I thought I did. I think my reaction to it, like when I went to bed the other night after doing some research, was like, wait. Like, from like the 1790s to 1914? What was going on?
yeah.
Right.
Oh, yeah.
Right? Like
Bad
1914
things,
is like,
Jared.
oh, that was a long time ago. But the answer is like, maybe it wasn't long enough.
It was bad. I don't know. I just thought like running your own mail order lottery, it just felt like a really 1960s or 70s kind of enterprise to me. I don't know why. It just felt right. But, honestly, the fact that this guy was running his mail order homebrew lottery in the 1910s, what a go-getter.
I know.
That's what
Impressive.
America's all about.
I mean, also
That's
it
what
shows
they-
like how solid the U.S. postal system is. Like, it just doesn't
Yeah.
get very much credit, but like
They're
it
going to
really.
deliver your illegal lottery tickets on time, even though it's 100 years ago.
Everybody, make sure you go personally thank and show gratitude to your local mail person. The next
Listen,
time that you see
everybody
them.
listening at home, you go to your stationery drawer right now. You go draw up a homebrew lottery card. It can be a bingo card. That's nice and easy.
No.
Wait,
Hit the music.
we're not endorsing this. Send it to your loved ones.
Yeah. Great thing about the U.S. mail, your mail-in ballot, it's gonna get there. Your illegal lottery entry, it's gonna get there.
The federal marshals probably won't open your mail to preempt your thought crimes.
Probably not. I mean, probably.
Who knows,
It's
honestly.
the exception clause. Wait, is that what we said? The exclusionary
exclusionary
rule.
Exclusionary.
Man, we learned something today, and I'm really proud of us.
Oh, I also wanted to mention the stuff that the police took, because I was reading this case, and that was really kind of came out to me. Once again, this case was heard in 1914. But let's see, it said that what was taken was one leather grip, value about $7, one tin box valued at $3, one Pettis County, Missouri bond value $500, 3 mining stock certificates, which defendant is unable to more particularly describe, valued at $12,000,
What?
and certain stock certificates, in addition thereto, issued by the San Domingo Mining Loan and Investment Company, about $75 in currency, a newspaper published in 1790, which is an heirloom, and like other property.
So wait a second. These people wrote their cryptocurrency on paper? Is that what you're telling me?
And all of this was in 1914. Once it got to the $500, I was like, wait, what? They took a lot of money.
Yeah, that's
Yeah.
insane.
We have the
12?
conversions if you'd like to hear.
Oh, yeah.
Yeah.
Oh,
What's
I
I
just
the-
want
looked it
to
up
know
myself,
more
too.
about this $12,000 piece of paper that they stole.
Yeah.
the mining certificates.
So
yeah.
the $7 leather grip would today, in today's money, would be worth $214.72. The tin
Sheesh.
box was $92.02. The $500 value, like bond, would have been $15,000, $15,337.
That one bond.
Yeah.
Wow.
The 12,000. What was the 12? Oh, $368,095.
Jeez.
Yeah.
I mean, if you walked into my house and took $368,095, I think I would also be like, "Hey, give that back."
If you walked into my house and took $200, I would be like, "Give me my shit back."
To be fair, if you walked into my house and stole a bunch of random papers, they probably wouldn't be worth anything. But I'd be upset anyway.
Because they're mine, damn it.
Yeah.
Those are my Pokemon memes that I printed on my paper with my ink.
So, I'm sure part of it was like, give me my lottery papers back. But like, it wasn't like, oh, my forms and blank paper. It was like actual stuff that was worth money.
Wow.
Yeah.
Yeah, I'd be pissed, honestly.
Yeah, it sucks.
We did the right thing today here, guys.
Agreed.
You can feel
I think
proud.
so.
Yeah.
Yeah.
We allowed this really
Even though he's illegal.
slick, like ahead of his time, I want to say, criminal, off the hook for his totally dope home lottery business. And I feel good about that.
Well, I don't know. Was he really off the hook? Because like all of this
Actually,
happened.
what happened to this guy?
Like all of this happened. So in order for the Supreme Court to like take a look, like you already have to go through and like be convicted and then work your way through the appeals process.
This guy
And
spent
then-
20 years in court.
I think it was a
Like-
3-year process. I think it was like
Yeah.
1911 where he was arrested.
And it's not clear to me whether he got his stuff back, actually.
Wow.
Oh no, the tin box.
No.
What about the newspaper?
Yeah, from
Heirloom.
1790, the
That's
heirloom.
insane.
Yeah, we don't know, like, because any discussion of this case is about, the exclusionary rule and so this guy, like, helped found, like, basically American, like, legal doctrine, but, like, he lost a bunch of his shit and probably went to jail or something.
Yeah.
We had to sacrifice a tin
Wow.
box and a whole bunch of homebrew lottery tickets to have protection from the cops stealing our shit, I guess.
When Nikki and I were talking about this a little bit earlier today, doing a sort of last minute prep, Nikki said something to me that I think is really sort of obvious in retrospect, but equally profound, which is like, just because it's in the Constitution doesn't actually really make it a right. It has to be violated, and then you have to sue, and then the courts have to affirm it's a right.
That's a good point.
Because that's what it feels
Yeah.
like, right? Like,
Yeah.
cops were like, I mean, it says we have to get a warrant, but like, if we don't and no one punishes us, then like, do we have to get one? And the answer is like, I guess not. But then the court was like, no, you do. And it's like, okay, now we know. Because even though it was written, we didn't know.
I mean, I bet you there was so much complaining about this decision when it came out, though. Like, just so much.
I have. Okay, so that's a perfect segue. So I want to do a shout out. So with these older cases, if anybody who's listening to this is interested in law, but it's just sort of getting into it, basically basically me, there is, so Oyez, which is like Oyez, if you do a Google search for that, that is a wonderful resource on Supreme Court cases. And for all of the cases that are recent enough that they were recorded, Oyez has the recordings. You can go listen to the oral
cool.
arguments. And it's great because then they also have the transcript, so you can read it. For cases old like this one, Nikki and I really have to rely on like whatever we can find. And the reality is we don't have a ton of time. Like, I would love to go to libraries and like look up newspapers in microfiches, and if I could.
And then
but I just
also
don't
like
have
a
the time to do
subscription
that.
to Nexus,
Yes.
whatever. It's
Yeah.
like,
So hey,
it's a lot
sponsors,
of money.
if you would like to sponsor us to get us access to that stuff, that'd be great. But one thing I did find was this article written by Gerard V. Bradley in 1986. It's a PDF that's available. If there's a way for me to post a link to the PDF wherever we post this, I will try to do that. The article's title, if anyone wants to look it up, is "Present at the Creation? A Critical Guide to Weeks v. United States and Its Progeny." And it was a great resource for me. But what it's really talking about is it's like a quick history of the exclusionary rule, which Weeks is obviously a major case in. And so that's where it kind of starts. And he has a really great quote from somebody from that time when this decision was handed down, who very much did not agree with this ruling. And this is a little bit of where I got the whole, like, if the cops screwed up, punish the cops. You don't just let someone go because someone else screwed up. Like, that doesn't make any sense. And so here's a quote from a gentleman. named Wigmore back in the day, around 1914 when this came out. He said, Titus, you've been found guilty of conducting a lottery. Flavius, you have confessedly violated the Constitution. Titus ought to suffer imprisonment for crime, and Flavius for contempt. But no, we shall let you both go free. We shall not punish Flavius directly, but shall do so by reversing Titus's conviction. This is our way of teaching people like Flavius to behave, and of teaching people like Titus to behave, and incidentally of securing respect for the Constitution. Our way of upholding the Constitution is not to strike at the man who breaks it, but to let off at somebody else who broke something else.
Wow, that's messy.
Like, obviously I wasn't going to directly quote the guy in my arguments. I was trying to get it in there in more modern language. I failed. Not that I think this argument probably moves you anyway. It doesn't move me, but it did make me stop and think that last line does kind of make sense a little bit.
Porque no los dos.
Yeah. So I think, so the Sarah court has issued the Porque no los dos doctrine.
Yep.
Yeah, no, this is excellent. I appreciate the discussion.
How's everybody feeling right now?
On the right side of history.
I feel like I could go be a lawyer now.
Yep.
Oh, you absolutely can.
I think we leveled up. Yeah, no, we're absolutely.
This was
we got some XP.
Yeah, we're acolyte lawyers now.
Ooh, nice.
Ready for a job change from whatever white collar nonsense I'm doing to this other white collar nonsense.
I'm already just shuffling papers. Can't they just be law papers?
Right? I want them to be officious and have the weight of history behind them.
Well, good job, team. Good job, my fellow court members.
I feel like we did a good law today.
Yes, I concur.
Hey, thanks to our thanks for everybody for being here. Thanks for the discussion.
Thanks for the prep.
Well,
thank you for considering my opinion important in really any context.
we look forward to chatting with you at the next one.
We're not lawyers.
Definitely. Oh god.
Oh boy.
I think everything that happened previous to this moment proves
it's
that.
Proof.
Yeah,
absolutely.
Pretty effectively.
Really drives that home.
So today, we had a unanimous decision in favor of Weeks in that the conviction should be overturned because the search was illegal. This ruling actually matches the real Supreme Court's ruling. Sarah also added that if police illegally searched for and seized evidence, then the charge should be dropped and the police should be punished. We're calling this the Porque no los dos doctrine. That's it for this episode, but before we go, thanks again to my co-host and to our justices. The music in this episode was written by Studio Columna and Toby Smith and provided by Pixabay. Audio mixing and producing was done by Jarrett. Thanks for listening. Please like and subscribe, and catch us at relitigated.com. Until then, I'm Nikki, and this has been Relitigated. Goodbye.